Hello, welcome to the Legal View. I'm Chuck Farah, and with me today is my partner, Eddie Farah. And today we're going to talk about how we go about obtaining the coverages available to compensate our client.
Thanks, Chuck. Under Florida law, once you put an insurance company on notice in writing asking for policy information, they must provide you with a copy of their insurance policy within 30 days. That way you know what kind of coverages you're dealing with and how much insurance is available. In our office, what we always like to do, we would like to request a certified copy of the policy that we know exactly what we're dealing with. A lot of times we found out in the past when you receive verbal acknowledgement of certain policy information, it's not always correct, or if they just send a regular letter with policy information, they may not be bound to that if that information turns out not to be correct. So you always want to request a certified copy of the policy. The same goes for any type of a premises liability case, any other liability case. Let's say you slip and fall in a big box store and you put them on notice in writing requesting a copy of the policy. They have 30 days to provide you with that. Same with a homeowner's claim. If you're injured on somebody's property, you can write their insurance company and you can find out who their insurance company is and how much coverage they have, and that information must be provided to you within 30 days. When you go to court, it's a whole different story. Isn't that right, Chuck?
It sure is. When we sue, or the law in the state of Florida is when you sue the opposing party, you sue that party in his name, his personal name, or in a company name. The insurance company is not part of the lawsuit. They're not named in the lawsuit. That's a big advantage for the insurance companies. When you get into trial, the mention of insurance is prohibited. You're not allowed to talk about the types of coverages available to the person that's injured. The jury's not allowed to hear anything regarding insurance. Even in cross-examination, direct examination, opening and closing statements, insurance cannot be mentioned. And if it is mentioned, it ends up mistrying the case, and the case has to start from the beginning again. So this is a really big advantage for the insurance companies.
Yeah, I tell you, the jury sits through a week-long trial, and I'll tell you, in probably 99.9% of all the cases, that's an insurance company defending that person who's being sued, and the insurance company is paying the verdict, whatever the verdict is. But the jury's sitting there for a week-long trial, and they think Mr. Smith is paying that money. You're right, that is a big advantage to the insurance company. But let the truth be known, insurance is involved in all these cases, and they're the ones who end up paying those verdicts.
Right, and the advantage comes because typically a jury may have more sympathy towards an individual if they don't know that there's coverage there, insurance coverage to pay the claim. So that's really where the advantage lies.
Yeah.